A lot of people do think it matters who makes the application, and that in sense speaking, the divorce petition, what's contained in that divorce petition will be against the other person.
Right.
So they'll be down, if it's, for example, unreasonable behaviour, which is one of the grounds.
Right.
If it's down as unreasonable behaviour, you would have to say what unreasonable behaviour the other party did for you wanting to have a divorce. A divorce. Yeah.
Right. Okay. And what? So the applicant that makes the application, you know, or files for a divorce petition, you know, is there any set documents that they need to sort of also produce, or any evidence as such?
Not so much evidence. You need your marriage certificate.
Okay.
There's forms that you would need to fill in correctly and submit them with the court. The court can sometimes come back and say, this is filled in wrong, can you fill it in again?
Right.
So the forms do need to be filled in correctly.
Okay. What if you don't have the marriage certificate?
You would have to get a copy of your marriage certificate.
Okay, and where can you obtain that from?
You can obtain it from the General Registry Office.
Okay.
If you can't get your marriage certificate at all, then you would need to make a separate application to the court to request that you can continue with the divorce without your marriage certificate. But then that's up to the judge to decide whether he would allow that.
Okay, now touching back on to, you said one of the grounds was unreasonable behaviour. Now, I know there's more than one, so can you just explain what the grounds are to go for a divorce?
Well, grounds-wise, there's only one, which is irretrievable breakdown of a marriage, which simply means that the marriage has broken down and there's no going back.
Oh, right, sorry, so I've got that wrong then. So there's only one ground?
Yeah, and then there's 5 facts that you would have to prove.
Okay.
First one being adultery. Second one is unreasonable behaviour, which is the most common.
Okay.
And then you have desertion. Then you have 2-year separation, but that's with consent. And then you have a 5-year separation.
Okay. I know it's a lot to ask, but can you explain a bit about these sort of the 5 factors that you just mentioned?
Yes. So adultery is simply one party has had another relationship with somebody not other than the husband and wife.
So do you need to show proof of that then?
Yes, you would need to show proof of that.
And what do we use?
Usually speaking, if the other party agrees to the divorce being on adultery, you can get something called a confession statement from them.
Right.
That assists. So basically they write it in black and white that they did this, and you send it to the court. And
but what if they don't do a confession statement? Then what?
Then the standard of proof is very high.
Right.
It has to be the sexual act as well. So it's not just having a relationship in the sense of being friends or being
so it's not just simply just text messages or just having
the sexual act. The law is perfectly clear on that. So the proof is, it wouldn't just be of the relationship, it would be proof of a sexual act, which has to be sexual intercourse to satisfy the ground.
Yes.
Okay.
And you would need proof of that.
Yeah.
Right. Okay.
The second one is unreasonable behaviour. That can be due to somebody's drug taking, the way they behave, physical abuse, emotional abuse. It can be as simple as down to the fact that they don't do the hoover. And you just cannot find it in yourself to live with this person anymore because of their behaviour.
So when you said the way they behave, what else?
Unacceptable to you, that you can't live with this person because of the way they're behaving.
So that could be a form of, you know, if they're always shouting at you or arguing, is that classed as just the way of
not helping with housework, things like that? It's a very low threshold.
So that's very open then, isn't it?
That's why it's the most common.
Most common.
Yeah.
But then say if the, is it respondent, the other party?
Yes, the other party.
So if they don't agree with what you've said for the for the facts of unreasonable behaviour, then what, can they defend that then?
Yes, they can. In most cases, the respondent, the other party, will never agree to what's been said in the divorce petition. They can defend it. It does rarely happen, simply because it costs a lot of money, and the outcome will still be the same. You're still going to be getting a divorce.
Right. Okay. So the third one you mentioned was
desertion. That's basically your husband or wife has left you. You don't know where they are. You've got no contact details. You don't know why they've left you. They've just simply gone.
Oh, right.
2-year separation with consent is that you have been separated for 2 years and the other party agrees to the divorce.
Does that mean then you have to get that consent in writing?
Yes. So you would they would simply sign a consent form to say that I accept that we have been separated since this date,
Right.
and then that would go with the divorce petition.
And what if they don't sign that consent form?
Then you can't apply for it.
You can't apply?
No.
Okay, so that's a must.
Yes, for your 2 years consent.
Consent.
And then the fifth one is 5-year separation.
Okay.
Yes, but you still need to try and obtain the consent if you can. If you can't, you need to show that you've tried to, even if you don't know where your partner is, you need to show that you've tried to find your partner. You could use a process server, you could use location services to show the court that, look, I have tried finding out where this person lives, I don't know, can I still continue with the divorce? Again, it's another separate application, and the judge will most likely say yes. If he can see that you've done what you can to try and find the other party, then they most likely will grant the divorce, will let you proceed with the petition.
Well, a question that's going to be on everyone's mind, because now you just mentioned about a tracing agent or process server, the fees. So that's going to be in addition to what the divorce is going to cost. So can you just give us like an approximate sort of figure, you know, what people could be looking at in paying for a divorce?
So the divorce petition fee is £550.
Right.
That's payable when you submit your divorce petition. Following that, if you have to make a separate application, as I've said, you might need to make separate applications if you need to show that you've tried to find your partner but you can't. There's a further fee of £50.
Okay.
But usually you are looking about £550.
So £550 is just the court fee?
Yes.
What about then the solicitor's cost? That's in addition?
That's in addition, and each solicitor will charge different costs.
So all in all, you know, what are you looking at then?
You're looking at maybe about 1,700, 1,800, yeah.
We do a fixed fee at Thursfield, which is 1,600, which includes the VAT and the court fee.
Right.
And also the provision to make a will, which is necessary when you get divorced.
Yes.
Yeah.
So some solicitors will do a fixed fee scheme.
Okay.
That's ours, and we also have fixed fees for if it's a respondent in the divorce. So if somebody's been served with divorce papers, they can get a fixed fee for that as well, which is 400 plus the VAT on that.
Okay, so I know you mentioned just for the court fee, it's just £550.
Yeah.
But is that something that you can try and recover? You know, if you're not the one at fault, and you say my husband should be paying for that, or my partner or my wife should be paying for that, can you try and make them pay for the court fee?
Yes. In the divorce petition, there is a question: do you want the other party to pay costs? Again, everybody ticks yes. They do want the other party to pay costs, and then the judge will say whether the respondent would have to pay the costs of the.
So it's up to the judge then to make that decision.
Yes.
Okay. And is it very rare that the judge will say no, or do they most likely say yes? The judge, or
they'll most likely say yes, but then it's up to the respondent to defend that if they wish to.
Okay. Now, a lot of people in our Asian community, obviously, Jasdeep, you may know that a lot of people do get married abroad.
Yes.
Whether this being either in India or in the United States, Canada, even in Europe. So if they've got married in another country, say for argument's sake in India, is that where they have to go to obtain a divorce, or can they make an application in this country?
No, if they got married in India but they're living in the UK and have been living in the UK, then they can apply for divorce in the UK.
Okay. And if they wanted to still make an application and divorce in the country that they got married in, they can still do that, can't they?
Yes, they can.
Okay.
If they're a resident of that country still.
Fair enough. What would happen to them? Couples that don't want to start a divorce proceeding because of now the costs that you've mentioned. I mean, what's the alternative sort of solution would you suggest?
There is legal separation, very similar to divorce, but in the fact that you're not showing that the marriage is irretrievably broken down, and you're just separated on paper. Although you're still married, you'll have a document to say that you are separated and you're not actually a couple.
Okay.
People that tend to go for that, maybe if they haven't been married for more than 1 year, they might go for that. Or people who, for religious reasons, don't want to get divorced, they may go for that. The other alternative that you would have is an annulment, but that is you have to be married less, well, you don't have to be married less than a year, but if you've been married less than a year, that's what you would go for, an annulment.
So what's an annulment? You know, just so it's...
Annulment is if your marriage is void or not valid in the first place.
And how can that be classed as not valid then?
There's different rules for each part of a marriage being void and a marriage being not valid.
Right.
It's a tricky one.
It's a tricky one. Is there like an example that you could possibly give?
So if the marriage hasn't been consummated, then that would be that marriage would be void.
Okay.
Yes.
So when you talk about like the legal separation, then, but does that mean then that the couple can still live under the same roof, or do they have to live in a separate household?
No, they could live under the same roof, but you would need to show that you're not living together. So you're not sharing meals, you're not sharing housework. You're living separate lives. So
in separate bedrooms, and you're sort of doing your own sort of chores and going to work, and the other partner's doing the same.
Yes.
Okay. Now, obviously, when you go through a whole divorce, there's it's a difficult time for everyone.
It is.
And you've also got to notify certain organisations or members or companies. Can you just let us know who they do need to notify, because you're not classed as a married person anymore.
No, you're not. So in the first instance, if somebody gets divorced, they might want to change their name back to their maiden name. Right. So you would obviously tell your employers, your HMRC, just to let them know that you're no longer married. If you're receiving any benefits, for example, child benefits, you would need to go back and tell them that you're now a single parent and you're not married anymore. Okay. So it's just your main local government authorities.
And passport and home office as well, if you're on a visa.
Oh, okay.
So if you've got a spousal visa, you would need to declare it to the Home Office and apply for a different type of visa.
Depending on what visa they've...
Yeah, so if you've got children, there's a visa that you can apply on because your child is habitually resident here.
Yeah.
There's a domestic violence visa as well, which is called a set DV. So there are different visas if you are getting divorced or going through the process. But that is important for people who have married perhaps out of jurisdiction and have moved here, but want to go back home or whatever they want to do. They would need to consider the visa implications for that.
Oh, okay. No, that's great. Thank you. Thanks for letting us know that. Now I know divorce is just straightforward petition that you're saying you make, take it to the courts, and obviously the judge can grant that. But what about with couples that have finances? Now that's a separate matter in itself to be dealt with. I know the terminology that people do tend to see it's called ancillary relief.
Yes.
So is that just another way of just saying finances, or is there more meaning to that?
No, that's just sorting out the division of the financial assets within a marriage.
Okay, and can you explain that sort of procedure then, or what it entails? And
yes, so the starting point the court look at is if you've had a long marriage, the starting point is splitting the assets 50-50. Now your assets can be your family home, any other properties that you may have which you rent out, any shops, businesses, it can be any.
And this also includes if the property's not, in joint names, it can be in your sole name as well.
Yes, even
so you still have to take that into consideration.
Yeah, you still take it into consideration, as well as your pensions, which a lot of people might think, well, my pension's not part of the matrimonial pot itself because I've worked all my life for that. It's my pension, but technically speaking, it's husband and wife's. So that forms part of your matrimonial assets.
So say some of the assets were before marriage, is that still classed in the financial pot then?
It can be, yes.
Oh, okay, so you've got to declare literally then everything.
Yes.
And what sort of documents do you need to produce for all that then?
Quite a lot. So you have to produce so if you've got a property, your mortgage papers, so we can see what the outstanding mortgage is, property valuation, how much is the house worth.
Right.
With your pension, you need to show a CETV, which is the cash equivalent transfer value of your pension. And if you own any cars, maybe with a high value, you need to show that, and bank statements.
So that's for all accounts?
12 months bank statements.
Okay, and what about if you have any debts as such, whether it's credit card or loans, does that is that included in the financial pot?
It is, yes.
Because I suppose it's not just, all your assets like the income versus the outgoings.
Yes.
It's the debts as well. But do you classify the debts jointly, or does it depend on who's taken out that?
The debts will be jointly as well.
Jointly as well. Yeah. Okay. And so what's the procedure or the process to begin the finances then? Is that again going to court?
The first instance, no.
Okay.
You should not go to court.
Okay.
You should try and resolve matters between yourself. If you can't resolve matters between yourself, then you can go to mediation, where there will be a mediator present and they will try and help you resolve matters yourself. If you do, then you can prepare something called a consent order, and then once that's prepared, you can send that into the court. The court will sign it and seal it, and then that's the end of your finances. It's been dealt with. If you go to mediation and you can't come to an agreement regarding your finances, your last course of action would be court proceedings.
So is that a must that you to attend mediation? Or
yes.
It is?
It is now. It never used to be. I think it's been about 2-3 years since they implemented it.
The government brought it in to try and help people resolve issues rather than keep going to court, because you used to get hundreds of applications a month where parties could reach agreement because the asset pool doesn't warrant the cost of court proceedings. So if you haven't got many assets, if your only asset is your full matrimonial home, or you've got a lot of debt, then you're much better to try and resolve it through mediation or through solicitor correspondence who can help you and advise you legally. But if you reach an agreement with mediation, they can provide a written document which we could then draft into a consent order. And your court fee is much less if you reach an agreement than it is if you ask the court to handle your matters.
So what are the costs that you're looking at, if you're taking this to court then?
If you are doing just a consent order, it's just the consent order fee for the court, which is £50. If you're going through the court proceedings, you've got your solicitor fees.
Right. So that's where it starts to escalate.
Possibly barrister fees. You would have
the initial court fee.
Initial application fee, which I believe is £255.
Yep.
£255.
Sorry, so what was the £50 fee then?
That's if you come to an agreement yourself and you want to send the court a consent order which says we agree to everything.
The final document then?
Yes.
So that's £50. So the initial court fee is £255.
If you want to start proceedings, yes.
Okay. If you can't resolve matters, then you'd have to pay the £255. But if you were going through your divorce and you reached agreement outside, either through mediation or through solicitors, then you wouldn't pay the £255 and the £50. You would just pay the £50.
Okay.
But if you issue court proceedings and then file the consent order, then you would have already paid the £255 and you still have to pay the £50 court fee unless you attend a hearing and you agree at the hearing, in which case the fee becomes void.
So what kind of hearings take place then to sort out the finances? I mean, is it quite straightforward that you just sort of go to court, talk about what your assets are, and that's it, they can finalise it? Yeah, you'll usually have 3 hearings. Okay.
The first hearing will be just to discuss what everybody wants. The judge may set directions to say, okay, so if there's a dispute regarding the valuation of the property, so the judge may say at that hearing, okay, everybody go away and let's get this property valued.
Right.
Let's get the pensions in. If somebody's not showing certain documents, the judge can say, well, this needs to be provided within X amount of days.
Right.
So the judge will give directions, and then you've got time between your first hearing and the second hearing to do all of that. Yes. And your second hearing will be regarding those documents.
Right.
And at each stage, you are advised to come to an agreement if you can.
Okay.
And then following your second hearing, once you've produced all the documents, if there's more documents that the judge wants to see or the other party wants to see, then you produce them. And then finally, you have your final hearing, which will, if you can't make a decision, the judge will make a decision.
Now, you just mentioned about if documents haven't been produced. So for argument's sake, if your partner hasn't produced all the bank statements, but you have them in your possession, or your client does, should I say, can they produce that to you and say, well, here's hers or his?
Technically speaking, no.
Oh, okay.
They shouldn't produce it to you.
Right.
And as a solicitor, it would be a very difficult position for us to be in if a client gave us documents belonging to another party. We would advise them to send them straight back.
Okay, so you
and
wouldn't
look at them.
You wouldn't look at them or nothing. You would. But would you tell the other side that you have them in your possession or not? Or just...
We wouldn't have them in our possession. We would give them back to the client, and the client should hand those back over to the person who actually owns those documents.
So is it a must then? Your client has to declare everything. I mean, have you ever experienced where the client has not declared everything and then it comes to light afterwards? I mean, then what can happen? I mean, are there court sanctions for that?
It'll always come to light if they haven't produced their documents, especially if the other party knows that they have this bank account. Where's that bank account gone?
Okay.
And if they start raising these questions, and if you go to hearing, the judge is also going to ask you that question, and eventually you might have to say yes. I have got another bank account. So it's always advisable to put everything on the table.
I suppose when you're in court, you're under oath, aren't you? As
yes,
well?
You are.
So you can't exactly tell lies there.
No.
So there isn't a set sort of court sanction as such. Then, if afterwards it comes to light, or
yeah, there would be. If you've lied under oath, it would be contempt of court, which is it's an imprisonable offence.
Right. Okay.
And that's from the financial disclosure right at the beginning. So if you don't include something and you've had the opportunity to do so, then you would be in breach of the court directions.
Okay.
Equally, if your solicitor is aware of documents that they haven't produced, then they would also be found in breach.
Okay.
And it is a serious offence. For us, it would be something that you would be struck off for. And you wouldn't be allowed to practice anymore. But for a lay person, somebody that's in these proceedings, you could be looking at prison.
Yeah.
Okay. Well, let's just take a quick short break, but we'll come back after the break and we'll talk more with Hollie Styles and Jasdeep Nagra. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. Welcome back. Joining me from Thursfield Solicitors are Hollie Styles and Jasdeep Nagra. Ladies, we were talking about a lot of the divorce and finances, so I do want to kind of move on to also sort of the children and sort of the domestic abuse side of things. Now, I know, Jasdeep, when you were talking about the divorce, you mentioned about the unreasonable behaviour, and that's classed as, the way someone behaves, and you mentioned about emotional and domestic abuse.
Yeah.
Now, Hollie, I know that's your sort of speciality, and I think people out there might just think domestic abuse is just a form of all physical, not verbal or emotional, but can you shed a bit more light onto that as to what is classed as domestic abuse?
Yeah, so the term domestic abuse or domestic violence, which is how it's set out in the law, is a really wide category. So it covers everything from snide remarks to emotional abuse, sexual abuse, financial abuse, so by manipulating people, controlling their bank accounts, not allowing people to have money, that's a form of abuse. All the way through to, your kind of stereotypical, what you would see on TV adverts in terms of bruises and things like that. That tends to be just one form of abuse, but it happens in so many different levels by so many different perpetrators. It doesn't necessarily have to be within the marriage.
So when you say, the bruises or sort of, and then you're talking about then sort of financial abuse or emotional abuse.
Yeah.
Now, you can show the evidence for the bruises as such, taking photographs of the marks on your body or wherever it is. But when you're saying about financial abuse and emotional, I mean, how do you prove that then? Or,
Well, there are two different courts, so to kind of make this clear. So in criminal courts, if you were looking for a criminal prosecution, you would be looking at beyond all reasonable doubt, which is a very high threshold.
Right.
However, in the family courts, we're much more open to the fact that so many forms of abuse happen and there are no signs. It happens behind closed doors. There are no witnesses very often.
Yeah.
And so we only have to satisfy in the balance of probabilities.
Okay.
So it's a very low threshold. In a sense, that makes it easier for people to make spurious allegations, but what it does is it protects those people that are more vulnerable. And so they might not see that they're being emotionally abused. There may be no signs of it, but actually when you sit down and have a conversation with them, they're able to tell you, these are the things that are happening. He rings me, I'm not allowed to go outside, I don't have any friends, things like that. That is emotional abuse.
So is that something then, you could advise people to, I don't know, make a note or keep a diary or a record of things?
Sometimes that's not appropriate because sometimes that puts people at more risk, as odd as it seems. But it's certainly something that if you are capable of doing and you're able to do, then that's something that we would recommend. If you have children, it's more prevalent with that, because that may become an issue later on in terms of children and where they're going to live and the relationships that they have.
Right.
So having a clear diary for those types of allegations is fine. But again, not all abuse is reported, and so it's not as easy to say, well, you know, on Wednesday this happened to me. You probably can recall the immediate instances, but in terms of if it's happened over a period of years and you've been groomed or you've been subject to it for a very long time, you're not going to be able to give dates, and the court is alive to that.
Yeah. Well, you mentioned about obviously the children. Obviously, we'll touch on that later in the show, because I want to focus about this domestic abuse that, you know, people can sort of, you know, go through in a divorce, or whether it's a couple as such.
Yeah, it doesn't have to be a marriage.
No, it doesn't have to be a marriage, but you know, who are classed as the victims of, you know, abuse, and who are classed as the perpetrators as such? Is it, you know, if it's a husband and wife, it's the, you know, the wife and the husband, or are there members outside the family that can still be classed as perpetrators?
Yeah. I mean, the Family Law Act gives us a whole breadth of people that can come under this umbrella in terms of seeking a civil order, which is what we're talking about in family court. Whereas the criminal court, it can be anybody, it can be a friend or a neighbour. You're not allowed to have that kind of scope in family. But it's not restricted to just husband and wife. You can be cohabitants, it can be somebody that has stayed with you or is living with you, it can be a relative or your partner's relative. So it could be, you know, your mother-in-law, your father-in-law, your grandparent-in-law, an aunt or a sister, somebody that is in that family.
So you can take them to court under the law?
Absolutely.
The law allows that here?
For a civil order.
For a civil order. So what's the actual then sort of procedure then, you know, to go down, you know, if you are a victim of domestic abuse, you know, what do they have to do? And again, it's going to be that cost as well. So if you can just let me know.
So in terms of how to proceed, there are two courses that we can go down. The one is what's called an ex parte application, so that means that we don't provide notice to the opponent. That tends to be used where we would say there's a high risk of harm likely to happen if the other person is aware that you're going to take them to court.
So is that like as an emergency?
Yes.
Then?
Yeah.
Right. And when you say an emergency, how quick can that happen then?
Same day.
Oh, okay.
If somebody calls me at 9 o'clock in the morning, I'll have it in court by the afternoon.
To get an order.
Absolutely.
Okay. And if it's not seen as urgent as, you know, as a high risk, then what's the procedure?
So then you could just apply on paper, so the same as any application. You would draft out the application. You have to file a witness statement with it in terms of what you're alleging.
Right.
Because the perpetrator has to be able to be accountable for those dates and times and those allegations. And there is no court fee. The big difference between domestic abuse and marriage law is that there is no court fee. Anybody can apply to court and they will not be penalised for doing so. Right.
And do you have to, obviously then, you know, if you're making a witness statement, do you have to then report everything to the police so then you can account for all that in your witness statement?
So we do recommend, if they've come to us, then they're obviously feeling a little bit confident in terms of how they're presenting, so they're perhaps found something that's given them strength. If they're at that stage, then I always recommend they speak to the domestic abuse team at the police. There is a special unit that deals with it, so they know how to handle it, especially if they're interviewing young adults and children. Then it needs to have a special approach rather than a normal policeman at a police station who would conduct the interview in an ordinary fashion, so to speak. So there are things that you can do, but you don't have to have reported it to the police. It's something that if you have, we'll request that so that we can evidence that to the court. But if you haven't done so, you can't be penalised for not doing so. Especially with the police, you know, they've had to change radically in the last couple of years how they look at domestic abuse, because originally it wasn't a crime.
Right. So when you do go to court, then, I mean, what is it that the judge can award a victim? You know, obviously that there are orders as such, but I think there's two of the main orders that you can,
yeah,
that a judge can grant? So
under a civil application, which is what we would be doing, it would be either a non-molestation order or an occupation order. Both are what we call injunctive orders.
Okay,
so
can you
they prevent...
explain the non-molestation then to begin with?
Okay, so a non-molestation order prevents somebody from conducting themselves in a way. So For a standard phrase that we would use is not to threaten, intimidate, harass, attack. You know, there are lots of things that we can include in there, dependent on the level of abuse and what the abuse is. Obviously, if it's
so it's depending on case by case.
Absolutely, but it will prevent somebody from doing a course of action, and you can have a warrant of arrest put on it. So if they were to continue to behave in that way, it would be an arrestable offence.
And how long do these orders last then? How long can you have it in force?
To start with, they normally, if you issue ex parte, they'll be in place for a week until you come back for a short hearing, and then they'll be reviewed.
Right.
Once they're reviewed, generally speaking, it'll be 6 months, but you can apply for that to be extended. They can go 12 months, they can also be indefinite, but the threshold obviously gets higher each time you're looking for it to be extended or an indefinite order.
And obviously then the perpetrator, by all means, they can try and defend that, can't they?
Absolutely.
And is there anything that they need as evidence, or is it just them attending that court and making...
The court will try and limit how many people become involved in it, because particularly with tight families, you get a lot of family members that want to say what they want to say to the court.
So I think you get that a lot in the Asian families.
Yeah, it's across the board, not just Asian families particularly, but you know, some families are just very tight groups of people. So they will try and cut out everybody that isn't really relevant. They will only want to hear from people that have witnessed the abuse. And as I said before, most abuse happens behind closed doors.
Okay. Then the other order that you mentioned was
occupation
order. So what does that entail then?
So an occupation order can exclude somebody from a home, and
even if it's your own home.
Absolutely.
The judge will allow that?
Yeah, it's a high threshold again. Everything is done by threshold, so the more severe the order, the higher the threshold to get it. So an occupation order can be made if there is a significant risk of harm or life to a particular person or a child. So the abuse doesn't have to be against the adult. The abuse could be against the child, and you could still seek the orders. And
what if the perpetrator doesn't have anywhere else to go?
It's a consideration. It's something that the court will consider, but it's not a bar. Certainly, you know, if the other person is earning and they're able to support themselves, there's no reason why they can't get themselves somewhere else to live. If they have family in the area, they have alternative accommodation available to them.
Okay. Now, I know you said, you know, the cost, there's no court fee as such, so... But what are the costs just generally in domestic abuse proceedings, like injunction proceedings, and what do they need to factor in?
So there are availabilities for legal aid under the legislation that's currently in force. To do that, you have to satisfy certain criteria, so you'd need to see a legal aid lawyer about that, and they will be able to advise you as to whether your case could get legal aid, which means it would be free or that you would have to pay a contribution, but it would be much lower than paying somebody on a private paying basis. If you're paying privately, then my estimate to start is to do the first 2 hearings plus all of the paperwork, you're looking probably at about £1,000 to £1,500 plus VAT.
Okay. Now, going back to when you mentioned about the emergency sort of hearing, you know, you go with your client to the hearing, you get is it ex parte order? And I mean, what happens? How does then the perpetrator become aware?
We would serve them.
Right.
So in some cases, the victim will hand the papers if they're happy to do that, or a family member. But ordinarily, I would be instructing a process server, so they would have a photograph.
If they've gone out and got an order, really, can they then be giving out?
If it's an occupation order, they'll be in the same house. So as long as they've got police assistance, we can have that. There are occasions where the police will serve. So if we are moving somebody out of a property physically, then the police will be able to assist with that, the same as on an injunction basis. They would assist and remove and serve at the same time. Otherwise, we'd be looking at a process server fee, which is normally about £78.
And then what if a perpetrator then doesn't agree with that order, that, you know, you've gone out on an emergency basis? I mean, then what happens?
It doesn't matter initially that they don't agree. They'll have that option to say what they want to the court. They'll be able to file a statement in response.
Right.
And that would all take place at the next hearing, where the court would consider whether we extend the order, whether we allow the order to remain in place, and whether we need to have any sort of reports from police or from Women's Aid, from refuges, things like that.
So there's a lot of support that comes with injunction proceedings, like you just mentioned, Women's Aid, Refuge. But that's obviously something that you as solicitors then discuss with your clients, I believe.
We have contacts in a wide range of support that's available for victims and perpetrators of DV. And so we can recommend to them that they need to go and seek some advice. You know, sometimes anger management is a big issue, and somebody recognises actually they need to control that a little bit better, and they want to seek the help. perhaps they've got a child, or perhaps they don't want their marriage to end, or for whatever reason. So it's important for us that we can signpost people to those sorts of help.
Well, you mentioned that, you know, perpetrators are not just classed as if it's a husband or a wife or, you know, partner as such, and there are other members that can be included in that. Can you just let us know who else can be classed as the perpetrator that can be taken to court?
So it can be parents, it can be grandparents, parents-in-law, grandparents-in-law, aunts, uncles, siblings, anybody really, nieces, uncles, nephews, they're all kind of included within that. Equally, if you live with somebody or they have lived with you, so they're what we would call a cohabitant or former cohabitant, and that also covers the gay, bisexual and transgender sector of community as well, because obviously some of those won't.
It covers a broad range of.
The only people that you wouldn't be able to are people perhaps that you live next door to, so they're not related to you in any way, shape or form. They don't live with you, but if they cause a problem, then that comes under criminal law rather than civil.
Okay. Now there could be people out, you know, that go through this sort of domestic abuse or emotional abuse, and they might be very scared to think, oh, I need to go and see a solicitor and then go and obtain this injunction. I mean, they might not be confident or 100%, you know, strong enough to do that, because there could be children involved, you know, they might be so scared. I mean, what other options are available to them if they don't want to go down the court route?
The only other option would be the criminal route, which would be to speak to the police, which is often more intimidating than coming to see somebody like myself. I offer a free half-an-hour consultation because it's not straightforward for people, and so sometimes they just need to know what is available when they're ready to do it. But absolutely, I don't push people into making a decision to issue, because if they're not ready to do it, generally speaking, it won't be worth their time and effort putting in to do the application properly.
And do you then, you know, are you able to go out and meet these victims, or do they come out to see you? I mean,
we can do it in a variety of settings. Ordinarily, they would come into the office because I would need ID and things first of all. But for a free half-an-hour consultation, they just come in, we have a chat about it. I will tell them what they're entitled to and how to help, signpost them to people that can support them if they need that, and then it's up to them. They'll come back when they're ready, or if they want to seek legal aid, then I can recommend them to firms that do that.
Now, I want to move on to the children's side of things, because that also sort of entails from the divorce, the finances, because obviously that's the children are also factored in the divorce and the finances, aren't they?
They're taken into consideration, but children, the whole aspect of children is usually done separately.
It used to be that it was part of the divorce process, but they separated the two because it clouds, so to speak. So children shouldn't be mixed with finances.
Oh, at all?
No.
Well, moving on to then the children. I mean, how is it dealt with then? You know, for example, if you are going through the whole divorce, finances, I mean, what happens with the children then, or how do you touch on that area then?
It depends on the family and depends on what they want to achieve. I mean, for me, you deal with divorce and that's your primary focus, so to speak. For me, I think, you know, the children is absolutely crucial to get right as early as possible, and to try and take away all of that animosity. So we'll work hard to try and reach an agreement between the parents. Again, mediation is an option, so if they go into mediation for finances, they can also go for children, and try and resolve, you know, where the children are going to live, what time they're going to have with the other parent, and all of those sorts of issues.
There's a lot to consider, like, I know before there used to be different set of orders like residence and contacts, but the law's changed on that now, hasn't it, Hollie? I mean, what's the law now?
So in 2014, the law changed, and we now have what we call a child arrangements order. So the court were finding that parents were getting particularly hung up on who was the resident parent, and who was the non-resident parent, and contact order seemed a bit brutal to some. So a child arrangements order is, if you like, a holistic approach to looking at all of the orders that are available, and the court has the option when you make any application for a child arrangements order to consider the 4 different types, so your previous, your residence, your contact, a prohibited steps order and a specific issue order. They can consider all of those at any point when they're considering children matters anyway.
So it all just comes under one order now?
Yeah.
Okay, and who can go for an application then? I mean, who's entitled to make...
So anybody with parental responsibility
so
is the starting point. Not necessarily, because you've also got same-sex couples now, and under the Human Embryo and Fertilisation Act, you can have two parents that are of the same sex.
Right.
So it's just the people that have parental responsibility, the people that are either on the birth certificate or have an order saying they've got PR or an agreement saying they've got PR, are automatically entitled to make an application. However, if you're not one of those people and you still, if it's your granddaughter, for example, that you want to see, then you can apply, but you have to cross another bar, which is an application for leave to make the application. So the courts will keep an eye out as to whether this is just being vindictive, for example, or whether there's no merit in the case proceeding. Then they'll take a view from the outset as to whether to allow that person to seek an order from the court.
So what if a mother or father, or if it's the same-sex couple, like you just said, you know, wants to go for full custody of that child or children? What's the procedure there? I mean, obviously they're going to make the application, there's going to be court costs involved, well, court fee as such. What does that entail and how much is that to make an application?
I think the initial thing to say as well is that anybody with parental responsibility can hold a child, and so what a lot of people don't realise is that if you don't have an order in place, there's no automatic right for the child to be with mother or father.
Right.
It can be with either or both, and that's entirely at the court's discretion as well as the parent's discretion. But if you get to a situation where things are hostile or you're not coming to an agreement and the children don't have the security and stability they need, then in order to issue an application you need to fill in what we would know as a C100 form, which carries a court fee of £215. You can get that fee waived if you're low income, or if you're in receipt of specific benefits, so you can get the 215 completely discharged.
But you've got to provide the evidence.
Yeah, so we would complete another form called an EX160, which would produce your bank statements, copy benefits, etc. And those two forms, if you're making allegations of harm, so if you're saying the child has suffered any harm, not adult harm, then you would also have to complete what's called a form C1A, and that just sets out the allegations, risk of child abduction, whether there are cross-jurisdictional issues, things like that the court has to be aware of from the
child abuse.
Absolutely.
But is that child abuse as a form from the parent as such, or could it be other members?
If its child has been exposed to any form of child abuse, the parents are responsible, because it's their job to make sure that child doesn't suffer. Because
sometimes you're living in extended families, so
absolutely.
I mean, you can put down if they've been exposed to that kind of harm.
Yeah. Because that becomes relevant if the child is going to stay at that property again, or how that relationship is going to be nurtured.
Okay, because obviously when you're going through the whole divorce situation, or if it's a cohabiting couple and they've become very hostile, and obviously then it's a sort of, I want full custody of the child. Yeah. And then you just think, well, hold on, that's not going to happen as such, because the courts have to look at the criteria. But what is it that the court look at first, for a child, or which parent they should live with? What do they look at first? So the overriding principle for anything to do with children is that their welfare is paramount. So the court doesn't care, so to speak, how the parents are, what they are, how they behave. That's a completely separate issue. They're only concerned in the child's welfare. So it doesn't matter if, the father says, well, I earn the most money, I should have the child. Irrelevant. Or I'm the one that, owns his property. It doesn't matter. Yeah, absolutely. So the court will look at the child's best interest first. And then there are some factors in the Children Act which set out, we call this the welfare checklist. That's what it's referred to through legal personnel. And that's a number of criteria, I think 10 in total, such as, the child's wishes and feelings, any harm that child has suffered or is likely to suffer, educational needs, emotional needs, financial needs, all of that would also be considered. But finances this is why finance and children are never mixed, is because it's not relevant in terms of the care that you can provide to a child. You just mentioned one of the welfare checklist, the child's wishes and feelings. Now, what if a child's, I don't know, 3 years old or 4? I mean, how can they say, I want to live with mummy or I want to live with daddy? I mean, is there a certain age that the courts will consider? So it's phrased the ascertainable wishes and feelings of a child, which sounds like a long sentence for the sake of it, but what it actually means is not necessarily what they're communicating verbally, but how their behaviour is. So if you've got a child as young as 3, then the person that is normally doing the day-to-day care, and you do normally have that in a relationship, be it male or female, there'll be one person that does the majority of the care throughout the night, throughout the day with that child. Then they are what we would recognise as a primary carer. Now, that doesn't give them any more rights or any bigger say in what happens to the child. It simply means that that's kind of the position. So upon separation, both parties are entitled to care for the child, and if they can manage to do that, then that's fine. There's no criticism of that.
But if they can't, then you would have what we would call a welfare report, and within that, the ascertainable wishes and feelings. So the child's relationship with both parents. If you have a child that's aged 10 and above, then their views are clearly recorded within that document.
Who makes that document, the welfare report?
So the welfare report would be prepared either by an agency called CAFCAS, which is a court-appointed separate body, which are family law specialists, predominantly ex-social workers, and children's guardians, so they represent children in a number of cases, or the local authority. So if there is a social worker involved, then the social worker will prepare the report because they have a hands-on experience with that child, so it makes sense. But they would record a variety of things, not necessarily just what the child is saying. You know, they would watch the child, the interaction. They make sure if the child is at school age, they speak to the child at school. So they're in a neutral setting where they feel safe and where they're surrounded by people they know. And then they would see them with each parent, and they would record whether there is any difference in the child's view, or how they explain how they're feeling. You know, if they can't justify why they want to live with their mum and they've always lived with their dad, then it's going to appear that that's perhaps pressurised, which isn't.
Because I know you also deal with a lot of cases where there's been child abduction or taking a child out of jurisdiction. I mean, what does that involve, Hollie?
So it's all under the same umbrella, it's all under the same area of law, but removal from jurisdiction is becoming more prominent purely because people are marrying people from other countries or having children with people. So, you know, you used to get a lot of one-night stands and somebody would live in Spain, and then where is that child going to live? As I said earlier, anyone with parental responsibility can make decisions for the child. So one parent decides unilaterally, well, I'm going to move my child to Sweden, and off they trot, and they think that's fine, and the other parent is left in shock because their child's now missing. So if we get wind of an application, so if a parent starts to behave suspiciously, so they're booking one-way tickets or they're requesting the child's passport and they don't travel, that would set alarm bells off, and you can apply them for a prohibited steps order.
Oh, okay.
So with somebody who is an American national or an Indian national, then we would also write to the embassy and we would notify them of the child's passport.
So you do take quick...
Put it on stop. Oh, absolutely. Within 24 hours, we can stop the passports, put out an all ports alert. If the child has been taken, then you're fighting the tide. So you're much better to get in initially.
As quick as possible.
Yeah. So that's why we can issue the application the same day. The same as domestic abuse. If you come in and tell us, we'll get it. The
so
papers
it's like an
into
ex
court.
parte.
Absolutely.
And is there a court fee for that, or is that?
Yeah, it's the same court fee for any Children Act case. So that's the 215.
Right.
Which again is waived if you're low income or benefits.
Low income. So again, so if you know if they can't agree as to where the child is to live, if it is abroad, it still comes through.
If the child is living here at the time that decision is made, and it's made unilaterally without consent of the other parent, then they can't do that. So you need to apply to court for a prohibited steps order. If you're the parent that's saying, well, actually, you know, my family live in America and I want to go back and live with my mum, then you would need to make an application called a specific issue order to remove the child from the jurisdiction. If you remove the child and you don't have the consent of the other parent, it is child abduction, regardless that you're parent. It doesn't matter. It can be anybody.
Yeah.
But then if you're a Hague Convention country coming into law, which is very technical, but if you're a Hague Convention country, we would invoke the Hague Convention and we would get the police to return the child, which is not great for the child, not great for the parent. So we would always encourage parents to try and come to an agreement, and if not, issue the court proceedings, let a judge make the decision.
So I think what the message you're trying to get across, or you know, I can see here to Hollie, is that parents, or whether it's even grandparents, because obviously grandparents can make an application as well, because they have rights to a certain extent, don't they? Yeah, they don't have any automatic rights. So I mentioned earlier about leave to apply. Grandparents would use that doorstep, if you like, but in today's society across Britain, grandparents play a massive role in rearing of children because generally they're retired, they're able to go and do school run, they can help out when they're toddlers. Sometimes they look after, you know, during the week time while the parents are out at work. And in some communities, they are the main carer because that's the role they take on, and you have to work. You're a young couple, you need to support yourselves, have a mortgage, whatever your situation is. And so grandparents can apply, but they would need leave of the court to do so. And is that then getting that permission first from the courts, and again, it's up to the judge's discretion to make that.
Yeah, and the court will always look at what the parents are doing. So if a grandparent has applied and perhaps they are the maternal grandparent, so mum's mum, then they will want to know why mum isn't promoting that relationship. Because if mum is, then they won't make an order, because it's not fair to mum to jeopardise her time with the children for grandparents.
And what if it's the father's parents?
It would be exactly the same. So if the children are having contact with father, then it's up to father to promote the relationship with grandparents. But if he's fallen out with parents or doesn't want to see them for whatever reason, then they could apply. But again, it will be taken really kind of into account from father's time with the children rather than mother's.
So I think the message is basically that you've parents or whoever it is have to put the children's first. Always. Whether it's in the divorce, the finances, even domestic abuse.
And this is why the court does not deal with children, divorce and finances anymore. They used to, and it just became almost like a bargaining game. Well, I have the children and therefore I'm going to do this. And that is how it becomes.
Well, ladies, that's all we have time for today. But thank you for joining me today and giving that information out, you know, for our viewers to take on board. But yeah, so thank you again.
Thank you.
And that's all we have time for today. But join me again next week on the Legal Advice Show. Joining me next week from Thursfield Solicitors will be the Insolvency and Debt Recovery team. Vaiguru Ji Ka Khalsa, Vaiguru Ji Ki Fateh.